If so, please raise your hand. All right, for the record, I see no hands raised. Did anybody inadvertently or otherwise see, read, watch, listen to anything on TV, radio, newspaper, social media regarding this case, or anything about the people or places involved in this case? If so, please raise your hand. All right, I see no hands raised. Thank you. So as you know, the state presented its closing yesterday, and at this time we'll call upon the defense for its close.
Thank you, Your Honor. The government didn't build a case. It bought one. An expensive expert, desperate snitches. But you can't buy your way past the truth. And the truth is, to quote Hakeem Robinson's sister, Blue's daughter, hell no. This is not the guy in the video. Let me walk you through some maps to explain what happened that day. Mike, if you would. So on January 15, 2020, Charles McCormick was at 7001 Merrill Road. Over at the Publix, you had Officer Jimmy Collins. At around 11 o'clock, Charles McCormick is shot and killed. The killers jump inside of the vehicle and they flee. Now, Officer Collins was fast enough, and you can see it in the dash cam video, that his car is parked down near that yellow line. He sprints. He doesn't run. His words. He sprints, gets into his cruiser, and gets behind that vehicle. And then there's a pursuit. They go out into Merrill Road, turn south, go all the way down to Townsend. Now, the first mark is where the car accident happens. A car crashes, 3 people jump out. 2 of them run south to Barbara Buckley's house. The focus for us here in our argument is the one that Officer Collins says runs westbound. Now, you heard some testimony. Officer Graham took the stand and talked to you about how he was in the area of Carlotta, saw somebody running westbound. Then, you also heard from Renata Boston, who lived at 7201 Arlington Expressway, that was also person that ran westbound. Now, an opening statement, which feels like months ago, Ms. Kawas got up here and said, watch what the government's going to do. They're going to tailor their evidence. They're not going to give it all to you. When you trust the facts of your case and you believe that the facts of your case are going to prove it beyond a reasonable doubt, you don't tailor it. You give it to the jury. As the government, you give it to the jury and let the jury decide. But that's not what we saw. Victor Kruger, he was back. He was in his vehicle. Dash cam, eerily music comes on when the shooting starts. He took the stand. The government didn't ask him for the description of the shooter. They left that out. I had to pull it out of him. I shouldn't have to do that as a defense, to pull it out of him, that what he saw was somebody that was very slight. Don't let this government get up here in their rebuttal and not answer the question to you why they didn't give that to you. Why are they tailoring it and giving you only the things that fit their case, but not those that are against it? Now, that applied to the witnesses as well, too. Jarvis Roberts, admittedly, he's far away, but he's a witness. Why did we have to call him? Jarvis, working at Hibbett Sports, is at his vehicle. It's only a couple of seconds. And he sees somebody and he describes it. It doesn't fit their case. They choose not to call that witness. I agree, they don't have to call everybody. But there's a handful of eyewitnesses. His testimony took minutes. Why did we have to call it? Don't let them get up here and not answer that question. Instead, they want to focus and get into a back and forth with Mr. Roberts that he was maybe 5 yards further away than he said. Was it 25? Was it 30 yards? Meanwhile, they're overlooking the inches and pounds discrepancy in between the descriptions in their case. Now, The reason why we're bringing the defense, we shouldn't have to, bringing all of these witnesses to you, is for one simple thing. A dozen people, including police officers, are not going to consistently get it wrong. 12 people would have to be wrong, but consistent. Not tall and stocky, short and skinny. That doesn't make sense. Also, us as human beings, we understand that if somebody's running, that's going to drop their height. If they're far away, it's going to drop their height. I don't think that the people that are in the back of the courtroom are 12 inches tall. I have depth perception. I have the ability to be able to say, it's at a distance. But there are some people, when you get up over 6 feet, when you get up over 200 pounds, not a lot of human beings are that size. And you can very quickly determine that is not a normal sized human being. That is not a normal sized human being. Stand up again. I'm a big guy. He makes me look small. Take a seat. So, talking about the witnesses that consistently, according to the government, get it wrong and describe somebody who's short and skinny. Michael Williams, military vet, undoubtedly has training in stressful situations. He gives a description that doesn't fit their case, so they don't call him. Maybe hoping that we won't call him. Why wouldn't they call him? His testimony was minutes. But he says stuff that goes against their case, consistent with everybody else. Next, we have Renata Boston. I'm sorry, I forgot somebody, and this one's important. Tashita Saunders. She was the one that was inside of the staffing place where Charles McCormick was right before. Now, anything that I'm saying here, I beg you, ask for the transcript. Fact check everything that I'm saying.
Yeah, sustained.
You've taken copious notes. I trust you remember the testimony, and you'll be able to fact check me in your own mind against the government. Tashita Saunders got up here, and the government questioned her. How tall is the shooter? Mr. Cooper then argued in his closing argument, taller than Charles McCormick. That is not what she said. We had to bring it out of her. Ms. Kawas on cross-examination, 5'8", 5'9", skinny. It's as if the government is trying to blur the lines to increase the height of the shooter and decrease the height of my client because it's the only way they can bridge that gap. We shouldn't have to give you what is the truth of what the witnesses said. Tashita Saunders said 5'8", 5'9". Not because if you say taller than Charles McCormick, well, that could go all the way up. She put a cap on it. We shouldn't have to bring it out. Now, Renata Boston. Renata Boston was not upstairs and ran downstairs. She was sitting on a wall talking to her friends. She sees somebody come out of the woods. She also gives a description that we had to get out, which is consistent with everybody else, short and skinny, and also the same height that Tashita Saunders gave, which was 5'8" to 5'9". We shouldn't have to pull this information out. Your government should give you the objective facts and let you as the people decide. By tailoring it, they're not doing their job. Now let's talk about law enforcement. So let's talk about then Detective Collins. And let's contrast that with reasonable witnesses, objective witnesses. You remember earlier in the trial there was a couple of crime scene techs, the DNA people, the fingerprint people. That is objective evidence. Objective witnesses, when they testify, they answer the question straight. They're not trying to, find the answer. Contrast that with Officer Collins and also Officer Smith. Now, on Collins, we know, and we have the CAD notes. 5686, on his direct examination, the government got that out, that's his badge number. I'll zoom in here for you. He gives a description of 5'5" to 5'9". I don't buy it for a second that, well, I'm not sure. He could have just said, black male with this type sweatshirt running, unknown height. But he gave a description. Because the reason why you wouldn't do that, then if there's anybody tall, that's not the guy we're looking for. He gave the description that he had in that moment. He tried to be cagey. Compare him to how the texts were. We asked a question, the DNA expert. It could have gotten on there because of the T-shirt. Yes. Instead, him, from the very beginning of the cross-examination, he showed that he was motivated. When I asked him, and I go, you ran track and field, he paused because he knew that that was going to be bad for his testimony. I then asked him, you have to think about whether you ran track and field? And then he goes, well, that was years ago. I'm not saying he's as fast as he was. I'm just saying that he's faster than this guy. 6'4", long legs, former runner, fit as anything as he took the stand. He wasn't given straight answers. Most importantly, we heard from Detective Smith, body cams. Where is Officer Collins' body cam that would have shown who he was chasing? At one point in his testimony, he talked about how recently he looked at the video and, he determined that he was wrong. People ask a question a lot on how wrongful convictions happen. That's how it happens. Because witnesses on the stand, Ms. Kawas and I have lived this case for years. We know the facts. And when he testified to that, you probably saw us jump up and our faces go beet red.
Yeah, sustained.
You saw the evolution of his testimony. He did what we're saying that the government is trying to do. They're trying to increase the size of the shooter to fill that gap. But what he doesn't realize is where he thinks that he's growing of the shooter, it's actually his own nose like Pinocchio. Because his lies, his attempt to lie, actually prove our point. Now the government, they showed a very small photo. This is their exhibit focused in. There's your shooter. All right, you can see right above him a black line in a window. That's Officer Collins. Now, if you toggle back and forth, you'll see that the shadow of the two is different. Now, I'm just pointing out a fact on what they didn't do. They talked about how there was a gradient at Renata Boston's home. What we don't know, and what we can't tell, is if that is perfectly flat, if there is a drop-off, even of an inch, from the driveway to the grass, and whether the grass is flat. I can assume the driveway is flat. But there may be a slight deviation. Now, in a case like this, an inch matters. But when you go back and forth between these two, it's important to notice that the shooter, and we'll talk about this in a moment, has something up underneath their hood. Latham testified that that would add easily a couple of inches. Now, Officer Collins got up there and said that he's 6'4". He looked about that, maybe 6'3". Sometimes guys will exaggerate, round it up, round it down. When you compare the two and put them side by side, and I'll draw a line in here for the window, right? And then I'll also do it for the window on the other side. So that's our point of reference. Now, if we estimate where the top of the head of the shooter is, because of what they have up underneath their head, that brings them roughly to the chin of Officer Collins. I don't know what the length of the average human head is from the top to the bottom, but I'm thinking it's at least 8 inches, 10 inches. They were hoping you wouldn't look at this closely, that he could just come in here and go, oh, I looked at this video years later, this very grainy, difficult to see video, and you want to know what? I was wrong. He was my height. That's preposterous, and the evidence shows that that is preposterous. We also heard from Officer Graham. We had to call him. They didn't. That's a police officer. Former police officer. We had to bring him in. He's one of the 2 police officers that chased on foot the shooter, unquestionably chased the shooter. Why are we calling that witness and why are they not? They're not calling the witness because of the height description that he gives. It conflicts with their case. It's consistent with all of the civilians that we brought in, all of the civilians that testified, and Collins. The important thing is this. Any big guy knows this. There's no way a guy that's 6'2", 6'3", 230 is going to outrun a cadet that had just gone through the academy, that is going to outrun a former track runner. That's going to be, and remember what Graham said, he was jumping fences. He was fast. They were even in their cruiser for a moment trying to chase him. He was that fast. That ain't him. Again, quote his sister, hell no. What was Hakeem Robinson like then? The government wants you to, say, well, photos didn't need to be taken. Remember, we're the ones that brought in the photographs the day before. We're the ones that had to bring that in, and we also brought in Howell. But if we look, this is when the scan was done, the big piece of the government's evidence. You see the build on Hakeem Robinson. Now, there's little point of reference here. If you put him up to, next to Miss Quas, a normal-sized human being, he's huge. But even in this, you can tell he's got a belly. He is out of shape. He is not toned. And, Your Honor, I hope that I can quote what I did the other day when I said the shooter ain't got no ass. He does. In the video that we had to enter in, from the JSO property room where they show, and it's in evidence, you can look at it, I'm not going to play it now.
I'm sorry, I missed what you said.
Entered into evidence as Defense Exhibit 3. He had to enter it.
Okay, I'm going to sustain the objection.
You can review Defense Exhibit 3, our exhibit. It shows Sergeant Howell walk out. And Sergeant Howell's 6 feet tall, like 300 pounds at the time. And Hakeem Robinson's taller than him. But you'll notice something as he's walking. Now, admittedly, he's wearing slides and he's walking. But big guys know this. They waddle a little bit. You ever seen a linebacker? The way that they walk? It's not the same as somebody who is fit and who is fast like the shooter. And you can see it. He has sort of a duck waddle in the way that he walks. It's a product of having big legs and being a big guy. Now, so in our exhibit we brought forward, now the government had an issue. Because Renata Boston says the person that walked out of the woods had shoulder-length dreads. Now, the government, they showed you an exhibit when my client was getting a pedicure, not a couple days later, it was almost a week later, 5 days later, and they showed from an angle of down where the hair, and one could think that looks like hair that's down to the chin because of the perspective of it. Our exhibit, our videos, shows what his hair was like 18 hours before this crime that he's accused of. He had short hair. He did not have shoulder-length dreads. There's no question. He did not have He did not have shoulder-length dreads. He had short twists. The government, though, has tried to fix this. They brought in a photograph. Of all of the photographs on Hakeem Robinson's phone, there are thousands, over nearly 5,500 photos. They find photos of the hood. They only show you a few of them. They tailor it. But again, this supports our argument. Now first, before I get into this, you look at the music videos, you notice, your times out in public before, he's not the only one with hair. If you look at the different type hairstyles in Charles McCormick's music video, in Hakeem Robin's music video, there's a lot of people that have long hair. But this proves a point if we jump into the details. You notice how Hakeem Robinson, because he has sort of a uniform hairstyle, that the back of the hood looks as if it's empty. Now, obviously, it's lifted up off his head, but the back, it's got just fabric. You compare that over to the shooter, that is a different head. That is a full hood. That is hair, that is something up underneath there. Not that hair. Those are not, I'll go back and forth, those are not the same heads. Mr. Cooper got up on his closing argument and he said, Hakeem Robinson is 6 feet. And again, we're talking about tailoring the evidence, trying to shrink Hakeem Robinson, trying to grow the shooter, trying to jam a square peg into a round hole. That is not what the evidence was. The evidence for his height from first Blue, are we to trust him or are we to not? Because he said 6'2", 6'3". Johnny Shipes, no motivation whatsoever, not in handcuffs, not looking at prison. He said, I'm 6 feet. He's a lot bigger than me. He doesn't even fit into my clothes. Latham got up on the stand. And that's not what Latham testified to. He goes, the government did not ask me to do a height assessment. He agreed that the poor posture, not measuring for height, was 6 feet and a quarter inch. But he also said that there is an error of margin, very small. And we talked about the black tape line. I asked him, and I go, how thick is that tape? And he goes, could be 1 inch, could be 2, could be 1.5 inches. Again, I wasn't asked to do a height assessment, and you can clearly see that Hakeem Robinson is taller than that. And then anybody knows, you get your height measured. When you go to the doctor's office, that little square is so small, so it forces you to put your feet together. You can get an accurate weight, you can get an accurate height. Again, they are trying to shrink Hakeem Robinson to fit. Stand up. You don't have to go based on that. You can look at him in this courtroom and make your own determination on the size of this man. Sorry, if we can back up. And also the size of his feet. You can make that determination on your own. And when you do that, you can take a seat. Go back and look at the tiny little feet on the shooter. Latham said he would have the ability to be able to figure out the length of things. He spent nearly $100K on that guy to get up here and say, yeah, maybe. You don't throw in a few more dollars to get an accurate measurement of that foot? Let's go now to Sergeant Smith. February 5th, he's already committed on who it is. That's not an investigation. Literally days later, he sees an Instagram post. Now, what he says is, I screen recorded the Instagram post. We don't have the other Instagram stories to know what other things were out there. He just found one and he's like, this is enough. And he then commits to subpoena the meta records of my client. He had a print before that. We embrace that. That print was on that gun. It doesn't mean that he was ever inside of the car. And you know that he was in a music video holding all his buddies' guns. He was committed at that point in time. Print, post, he was done. His job was done. That's my case, but it wasn't enough. We got to build it a little bit more. Now let's compare this over to the other people that we know were involved. Barner, Butter, Blue, Abdul Sr., Abdul Jr., Torgon Williams, Natalie Bryan, Chris Brown. None of them posted anything. We use a phrase in these courtrooms every now and then, consciousness of guilt. That's consciousness of innocence. I'm going to post something, would be wildly, days later, wildly stupid. The only person that's going to do that is somebody who is confident in their innocence. I am using this because this, unfortunately, and look, I don't condone it. I'm not a drill rap fan. But it sells records. And it gets followers. But him co-opting a lifestyle of people that grew up around him as an artist doesn't mean that he's the one that committed it. I mean, look, country music stars talk about, murder. And look, I understand somebody actually died here. Rock stars will scream about murder. Other rappers will do it. We don't say that's a confession. But when it's a 21-year-old black kid from Jacksonville, it is. We're talking about the government and the way that they're trying to tailor the evidence. An opening statement. Mr. Cooper got up here and he showed you that post and he read it. I am never going to read that post. I don't have that right. First, they're assuming that's what it means. Right? Somebody could have a good day in court, post online, I killed it today. All right, so they want you to speculate that's what it means. But let's assume arguendo, that's what it means. So the government gets up here and they go a couple days later. A couple is 2, not 5. And then he says, getting his tired feet to try to say, oh, he ran and then went and got a pedicure after that. Again, 5 days later, nobody else is posting stuff. Everybody was trying to get away with this crime, and apparently he just goes out on public to his hundreds of thousands of followers, JSO watching, and confesses. The problem is that, look, there's 2 ways that you can look at the world. You can look at it through clean windows or dirty windows. You look at the world through clean windows, you're looking at it objectively. You start looking at it through dirty windows, everything you see is dirty. And that's what former Detective Smith, now Sergeant, did. He committed, and everything he looked at for Hakeem Robinson was through dirty windows. He was a hammer. That kid was a nail. He didn't look at anything else, despite the fact that there is clearly motive of other people. Chris Brown. We're not arguing that Chris Brown is the one that committed. I don't come into court and make speculative allegations. There was more than enough to look at it. So, Chris Brown. Renata Boston says that the guy that comes out of the woods has shoulder-length dreads. Natalie Gant gave us that little tidbit as well, too. Oh, yeah, shoulder-length dreads. Didn't have shoulder-length dreads, not even close. Butter pecan skin. It's clearly more brown than it is my client. I can't say that I confidently know what butter pecan skin is. I'm thinking of ice cream, but I'm thinking that it's more close to this guy. But there's one other glaring issue with that. Rothermill case. The murder crew is blue, butter, and brown. Crazy Chris. They literally have another murder case tied to Willie Addison. Smith gets up here and he goes, I don't even know his phone number. Talked about it in voir dire. You have to objectively investigate. You can't commit to a case, to a murder case, that is going to change the lives of so many people 2 weeks into the case. If he were looking at this case objectively, he would have looked into Brown. Oh, and don't forget, and I almost forgot this, Barner said Brown was involved. Now, someone would ask, well, why would Barner do that? I'm not asking you to understand the motives of a reliable hitman. I can't get inside of that guy's mind. I don't think any of us can. But is it crazy to think that in his mind he's thinking, first, I got to go with their narrative. But also, the more people I give them, the better my deal's going to be. Yeah, Chris Brown on 2 cases. That's not going to do much. But if you get more people, you can say, I gave you all of these people. There was plenty of people that had a motivation. It came out through Latham, it came out through Brown, it came out through other witnesses, that there was plenty of other people that would have been upset with what Charles McCormick did. None of them were looked at. None of them were evaluated. Instead, they spent the $100,000 to say that it wasn't 2 other people that we were never arguing that it was. They never acquired any records of Chris Brown. His Instagram, his cell phone records, nothing. Same thing with Dominique Barner as well, too. They don't get his Instagram stuff, and he said that he was on Instagram. He used it to stalk his prey, and also his iCloud stuff. It's willful ignorance. Now, I'm not saying that Smith sat down and go, you know what, I'm going to jam this kid. I'm going to make a choice not to look at it. But he lacked all objectivity within minutes on the case and didn't look at anything else, wouldn't even consider it. Let's change gears now and talk about House of Pain. So we're going to go into the topic now and talk about all the communications and the cell stuff. The government, like they're trying to link, they're trying to shrink Hakeem Robinson, grow the shooter. They're trying to bridge a gap as well, too, with the cell phone communications. They're invisible dots, imaginary lines. They're trying to get you to speculate. Now, first, they're trying to both say that, Hakeem Robinson was involved, that 478-305-9583 number, that was his, that he was using it. They're trying to connect all of that. But that's not what came out. They'll argue it, but it's not what came out, and that's why we're going to go over it here. First, with respect to the House of Pain email account, and they're trying to say, well, there's selfies of Hakeem Robinson in that account. Now, we know that Blue was trying to be the manager of his son, especially when his career was taking off. And any Apple iPhone user knows that you can combine, you can share photo albums. You know what makes sense as well? Something that they haven't disproved because they didn't get any of the further records, that he's uploading photos to his father's account so that his father can manage his Instagram page, to do something as a manager to justify getting payment. I'm not saying that's what happened. I'm saying that there is a hole in there that they're saying, well, they're selfies, it must be his phone, it must be him that's doing it. They could have gotten to the source of it. They could have gotten the Gmail records for that account. They could have gotten Blue's Instagram account, literally HOP, House of Pain CEO. But they didn't. Some could say willful ignorance. I'm saying that it's Sergeant Smith, Detective Smith deciding. It doesn't matter. I'm committed on what it is. Now, there's anomalies within the cell communications. Now, they've never actually tied Hakeem Robinson to that 478-305-9583. Smith got up here and he tried to say, well, the IP address, the first 4. He's not an expert. We heard from 2 other cell phone experts. They were never presented with that information. He tried to say, well, the provider told me, that's hearsay. The provider told me that, it's the first 4, not the last 4, but I subpoenaed the wrong one. It was a 7, it was a 1, but yeah, it could be. Now, the government tried to say that based on what he said, it's a link. His words, could be. But even that is not even close to a connection. They had an FBI cast member agent up on the stand, didn't ask him any of those questions. You best believe that if they tied the IP address of that phone to my client, you would have had an expert from T-Mobile sitting in here going, here's your link. But instead we had Smith get up there and go, yeah, it could be. They're trying to blur the line, trying to connect him to the shooter and the phone to Mr. Robinson. Now, Blue says that he was worried about his son. Given his testimony, I don't think he cares about his son at all. But he says, you know what, I cared about my son. Whether it's him caring or not, there is not a single phone call to that number. You would think that if this is the phone that is being used in the commission of the crime, that somebody would be repeatedly calling it. Now they'll get up here and say, well, it could be a FaceTime call. We have no record of it in a date event. Translation, they want you to speculate. They have never connected that phone over to the shooting. There are communications with one of the people much earlier, not during. There's a pin drop, could be in an area. They're wanting you to speculate. They need you to speculate because they have not made the connection. You remember, too, that they have the color-coded, they may show it to you here, that the red stands for that they even want to connect it before they've connected it, because the 478 number is in red, and so is my client's known 1595 number. They have it both in red. The interesting thing is that throughout the entire time of the commission of the crime, you see no red. It's everybody else. Now, mistakes and anomalies with respect to glaring mistake. The cast agent 7259, 7529, they admit it was a mistake, it wasn't entered incorrectly. Look, you know, in other lines of work, could it be a scrivener's error? Oh, I thought you wanted it medium rare, not well done. In a murder trial, when you're trying to explain, to have a jury make a decision beyond a reasonable doubt, there's no mistakes. That was a mistake. And then we also have the anomalies with AT&T. And he said it, he goes, look, you know, we can't, 95, I forget what the exact percentage was, but he's like, we don't use it because of the anomalies. But they still want you to trust some of the AT&T records. So, staying on the topic of the phones. Now, they brought up in the closing argument that Abdul Jr. had a phone that was registered to Darrell Watts, and that the 478 number was tied to Darrell Watts. What they're leaving out is that Ballou's main number was also registered to Darrell Watts. They also brought up this exhibit. It's a nice picture of Ballou. He looks like he's, you know, indecisive, not the felon that he is. And they said, he's not going to send a message to himself. His email is literally right there, as if you're not going to see it. It's insulting. From his number, 2370, which is under Darrell Watts, sending it to 9583, and abdulrobinson71@gmail. Abdul Robinson Sr., born in the 70s, definitely not my client's email. They showed you this photo and made the argument he'd never send it to himself, where literally it shows that he sent it to himself. Talk about the DNA and the fingerprints. We, of course, embrace there is DNA on a shirt. I think it may be out here, maybe a little bit, but you know, with the white shirt. Doesn't prove that he ever wore it. We talked about it with the expert. If I were to take my client's handkerchief and wipe my brow, my DNA is going to be on it. And she also testified how that very easily could be the reason why there is a mixture, because they take a swab and they do the entire compartment, and that very much could explain, well, the t-shirt's sitting there, then we wipe everything, why there's a mixture and why it's so low. But we embrace that. His DNA is showing up on a shirt that's in the car and also on the dash. He was friends with these people. He rapped about the life that he lived. We are not denying that. He was around them. He knew them. Wasn't doing what they were doing, which is why he isn't covered in tattoos and bullet holes, because he's not living that life. Fingerprint, the music videos. So again, we embrace this, but none of that, and I don't need to go over it because I know you saw the testimony. But they both agreed objectively in their testimony, I cannot say he was ever inside of that vehicle. What we know is that his fingerprints are not in the vehicle, and there is not a 700 billion DNA reading of inside of the vehicle. There's a small mixture, and the DNA expert got up there and said, yeah, it easily could have been transferred by the T-shirt. The reason why the government's probably arguing it is because they know jurors like DNA and fingerprints. No, it's like that silver bullet, but not here. This means all it proves is that he knows people that we already agree he knows. The other evidence shows that. So don't let them sway you with the idea of DNA and fingerprints. At the same time, too, we have Chifton Hogan. If their rationale of anybody whose DNA is found inside of the car, well, you know, they must be involved. Chifton Hogan and Blue said, oh, yeah, that's a family member to some extent. Anything that supports our argument that if you know people, your DNA could show up inside of their vehicle. Talk about the witnesses in this case. Latham, the expert. The government, and I said this before, they paid $80K, $70K, $80K, I don't know how much his expenses were flying back and forth and lodging, to come in here and say, yeah, maybe. Meanwhile, all of the witnesses consistently describe somebody that's short and skinny. Then they arrest a guy who's 6'2", 6'3", 230 pounds. That's not how the truth works. That's how desperation looks. Latham up on the stand, and I asked him, and I go, can you exclude me without scanning me? And his answer is no. And from that you can take, there's nothing unique about what he's saying. He can confidently say, well, it's not Leroy Whitaker, it's not Dominique Barner, not being argued here. But nothing more. Now the government, in their argument, they have brought up this photo. Now we have to talk about Charles McCormick's height and weight. Latham said, well, you know, they provided the information to me and I do the analysis. And what they gave me is that Charles McCormick was 5'10". There's a problem with that though, because I had to bring it out through the medical examiner, and he goes, that's just an estimate. Post-mortem, there are differences. Could be 5'9", could be 5'11". Also, this person is wearing shoes. So when that was brought up with Latham, he goes, I was given 5'10". I then. They call the medical examiner, and the medical examiner tells you that's not, I can't say that's an accurate height. But they want to do this comparison in between somebody who's 5'10", and then over to the shooter. We know that Charles McCormick was 143 pounds. We know that definitively. When you compare that over to the person next to him now, Charles McCormick is obviously turned a little bit, and they're not in the exact same posture, and I'm not denying that. But I could also make the argument that he's wearing darker clothes, which makes things look smaller, and the shooter is wearing light clothes, which make things look bigger. What you don't see is a huge difference, 100-pound difference between the two people. See, two skinny guys. Also, as for the height, yes, they are moving, they're dropped down. Let's do some math here. Hakeem Robinson, let's give him an inch, we'll say 6'2". Shoes, that's another inch. So he's at 6'3". Add then 3 inches on top of the head under that hood. That person's pushing 6'5", 6'6". If that were Hakeem Robinson next to Charles McCormick, 5'9", whatever it is, he would be way taller. But he's not. Again, the government's trying to shrink it They're glossing over the 3 inches that Latham said, yeah, that could easily be 3 inches on top of his head. I submit to you it could be more. If Akeem Robinson, those little tiny feet, there's no escaping those little tiny feet. You add an inch onto him, 6'2", 6'3", then whatever's underneath that head, that person is going to be a giant. You are not going to mistake that person for short and skinny, not a dozen times in a row. But they want to get up here and say, Charles McCormick, 5'10", despite what the witnesses said. Akeem Robinson, 6 feet. They're tailoring their evidence because they know that the evidence itself, the facts, suck. Now, they may get up here and say, well, you know, we didn't need these witnesses. You cut a deal with violent felons and you don't need them? You cut a deal with Barnum, who's a reliable hitman. You only get the reliable hitman term if you have killed. We know that in these cases there's nothing to establish him as a reliable. In Rothermill, they killed the wrong person, an innocent guy in a bike. On this one, he gets caught, but he's a reliable hitman. Sounds more like he's a serial killer. They may get up here and say, well, you know, we didn't need these witnesses. Our case was strong enough. Then why cut those deals? He could be out in a matter of years. Blue has a likelihood of being out in a matter of months. That's desperation. Don't let them get up here and say, well, we didn't need it. They did. That's why they cut reprehensible deals with violent criminals. There's an internal conflict with their testimony, right? Now, they're felons. They're cooperating to get a deal. Let's put that aside for a second. So Barnard gets up on the stand and says in the Rothermill case, implicating Blue on how he could have been charged with much more than accessory, provided items. Blue got up there and he denied. So which one's lying? It's not our job to prove it, it's theirs to prove, okay, well this one's lying, but that one's telling the truth. As it stands before you right now, you have no idea. Schrodinger's cat. You have no idea who is telling the truth. But they want to put them up. They want you to trust these people, that they're pillars of truth. Because they came to them in handcuffs. Don't trust Johnny Shipes or Blue's daughter, who have no motive, and if anything, reasons not to come forward and testify. Mr. Shipes, Mr. Shapiro, because of his business. Blue's daughter, because she's basically saying that her father's lying in front of the judge that we'll be sentencing him. They have no motive. But no. Trust the people that came to us in handcuffs. Trust the people that we have on a physical leash to tell the truth. And again, we set aside the fact that they are murderers and felons. Don't let them get up here and tell you they're both telling the truth, that either of them are telling the truth when they didn't clear up that internal conflict in their own testimony. Now, Natalie Gant. They said in their closing argument, well, she had no motive. She absolutely did. You could see it on cross-examination. I could feel the breeze from her lashes fluttering at the counsel table as she was getting cross-examined about the motive that she has. Now, it's not about what this government thinks. So they sit there and smirk at you. It's not about what they think. It's about what that witness thinks when she's sitting on the stand. She knows Dominique Barnard has implicated me in this case. I don't want to get charged. I'm going to do whatever the government says. Oh, and her husband sitting in prison being prosecuted by their office. It's about what's in her mind and the reason why she would have to tailor her evidence. Now, the government says, well, she didn't have all the details. She's older. She's not like the men she dates. She's smart. She knows if she commits too much, it could actually cause a problem. Oh, I don't remember what he was wearing. Because if she were to say the wrong thing, she's not usable. She hurts their case, potentially gets them mad, which is bad for her and her mind and her husband. The handguns. How would Barner know to say that the handgun was, look, Barner is not, I'm not saying he's book smart, but he's definitely street smart. He knows that there was, okay, and he was sitting on his case. He was getting prosecuted for months, looking at discovery before he ever made the decision to flip. He was arrested on the home invasion robbery. He had a whole bunch of records, and we're going to come back to that, on how he could have done what he did. But why would he claim that gun? Well, he knows that there's 3 guns in the vehicle. All right, one of them was used to commit a murder. The other one is a big machine gun. Yeah, that one's mine. Gave him musical chairs. He had to claim one. 3 people in the car, 3 guns. That one's mine. I'm not saying that the government, and if it's ever come off like this, I want to make this clear. I'm not saying that the government sat down with these witnesses and said, we need you to say this. Not saying that. Never would. But what I am saying is that they gave an opportunity to some really dangerous people. Dominique Barner is resourceful. He went on the court's computer system to stalk his prey, created fake Instagram accounts to figure things out in locations. He has a discovery on his case. We know that the first thing that was collected by Sergeant Smith were my client's meta records. The very first thing. Florida's a discovery state. This guy wants the government to be happy with him. They gave him too much of an opportunity. Now, the argument that we make over the recording, look, and we won't say it, the government has a right to talk to their witnesses. They're doing the work they need to do. They're talking to their witnesses. That's not our problem. Our problem is that the first and the second time they spoke to him, we have no idea what happened. Now, again, I'm not saying that these prosecutors told him what to say, but I do have any concern when the government is doing things behind closed doors, our government, without an ability to see it. And when they spoke to Dominique Barner the second time, Sergeant Smith told us they were leading questions. If you're getting the truth out of somebody, you don't have to lead them. You were driving the car. Hakeem Robinson was in the car. They're giving an opportunity for somebody to say the facts that they know the government wants to hear. And that's a problem that I have, that they allowed him that opportunity. Somebody that they knew was dangerous. Look, that serial killer has no problem taking a life. He has no problem lying to save himself. Sadly, we have no recording of the initial meeting. We don't know how he was able to get his facts straight, but I do know meta records are in the possession of law enforcement months before he cooperates. Florida is a discovery state, and he gets up there in another one of those times where we get new testimony. Oh yeah, he called Raekwon. You can clearly see that in the records. But what the government won't embrace is that my client's regularly talking to Raekwon, somebody that he's supposedly supposed to have a problem with. What that proves is he doesn't have a problem with these people, which is why he doesn't have bullet holes in him, that he's not living that life, that he's not tatted up. And we also know it because after that, Raekwon Howard tried to kill people that we know were involved. Didn't go after the guy that he's talking to regularly and joking around with. So, it's very easy for somebody like Dominique Barner in a meeting. You know, Dominique's sitting there. Did Hakeem make any phone calls in the car? In the questions being asked by a prosecutor that's holding a stack of papers. Barner's smart enough to go, yeah. It's that simple, and it's that easy for that to evolve into, yeah, he was talking to, yeah. And that's ruling out the fact that he has the records. He was involved. He's going to get some of the facts correct. But he's also resourceful, again, on hunting his prey. This time the prey was Hakeem Robinson. Now let's turn to Blue. Sat up here, fake tears for my son. Y'all saw it, there was no tears. He had that emotional pause. Yet he had no emotion when he was talking about the murder of his other son, Willie Addison. Abdul Robinson's daughter, no motive. If anything, reasons not to. I mean, of course, she doesn't want her brother wrongfully convicted. But she has reasons not to testify as well, too. Jonathan Shapiro, Johnny Shipes, no benefit, risk. Both of them gave a description of the height and a weight of Hakeem Robinson around that time. And it's inconsistent with what the government's saying. So, the government may get up here and talk about the fact that Varner and Blue are not sentenced yet, and that they don't know what they're going to get. That's by design. They got to make sure that they're dangling that carrot in front of them so that they do what they want them to do. It's also so that you as the jury don't hear what is potentially an offensive sentence that they get because of their recommendation. They want you to think, well, they could get life. There's no reason why they couldn't have been sentenced before coming in here. Now, one thing I want to go back on that I did miss. It's a really big point. And it's that both of them said, in government, I invite you to get up here and explain this one, that both of them said, Dominique Barner and Abdul Robinson Sr., have to say KSOO to get the deal. Those are their words. I have to say KSOO to get the deal. Let's talk about the jury instructions for a minute. I'm almost done here. So, when you go back into the jury room, one of the instructions you're going to get is weighing the evidence. And this is an opportunity for you to evaluate a witness's testimony. And these are things that the law in Florida says you got to be cautious of. We need to point this out to you because this could lead to a miscarriage of justice. Did the witness have some interest in how the case should be decided? Yeah, they're not spending life in prison. They're not getting prosecuted on multiple cases. Does the witness's testimony agree with the other testimony and other evidence in the case? I submit to you it doesn't. There's not massive conflicts, but there's definitely irreconcilable conflicts between their testimony. Has a witness been offered or received any money? We've already talked about Latham. Preferred treatment or other benefit in order to get the witness to testify. We are going to charge you with principle to murder. You're looking at life. You're a convicted felon 2 times prior. If you say what we want you to say, we'll recommend 72 months. Has any pressure or threat been used against a witness that affected the truth of the witness's testimony? You'll get out in 72 months, but you got to say KSOO or otherwise you're looking at principle to murder. Did the witness at some other time make a statement that is inconsistent with the testimony he gave in court? Yes. Has the witness been convicted of a felony? Both of them, yes. Just one of these is enough. They're hitting almost all of them. They're not just felons. They're not just convicted felons. They're felons who traded a story for a deal to save themselves. They sat down with the state and told them what they wanted to hear, not because it was the truth, but because it was the price of their freedom. It's not justice. Bargaining with guilt. The government wants you to trust them over all of the other objective, unbiased, unmotivated witnesses. That's scary. You know, the they may get up here and talk to you about reasonable doubt and say, you know, look, my job is I got to get you in a boat across this river. There could be holes in the boat, but I've got to get you across the river. Now, I want to change and use that example, instead talk about waver and vacillate, because that's what reasonable doubt is. You're standing there on the shore, you're looking at the boat. The boat, got some holes, some water's coming in. You're told that there are anomalies with the boat, it was manufactured incorrectly and there's problems. Any reasonable person's going to be sitting there going, I don't know. That's waver and vacillate. But add on top of that, the two people that are captaining the boat are violent felons, and they're telling you, hey, this boat's fine. No reasonable person's getting into that boat, and that's what they're asking you to do. Let's talk about their burden. Their burden of proof. I'm not going to go through this or spend much time on it, but just for the illustration of what we're talking about beyond a reasonable doubt. Everything else below that, strong belief, guilt likely, probably guilty, possibly guilty, none of that is enough for them to carry their burden. They have got to be able to rule. They have got to be able to rule out every other possibility. But the case that they presented to you, there's a whole bunch of other reasonable ones.
All right. The jury will listen to the instructions as I provide them to you, but you may proceed with argument.
They can't carry that burden. They have too many holes in their case, which is why they're not embracing the actual facts of the case and instead trying to mislead you. Now, whomever from the government gets up here and does the rebuttal, they may try to sway you with emotion, show you photos of Charles McCormick, talk about the tragedy. So let me save them that time and do it here for you. What happened to Charles McCormick, what happened to his family was tragic. No parent should have to bury a child. It's horrible. Convicting the wrong person doesn't fix that. It makes sure that the person that actually committed it, or other persons, go free. It doesn't protect us here in Duval County. Hakeem Robinson deserves better. The people of Duval County deserve better than Detective Smith getting up there going, yeah, that post is enough. The McCormick family deserves better than that. The emotion of this, the understandable emotion of this case, though, there's no place here. That's an attempt potentially to sway you into a verdict because the facts aren't enough to do it. So I'll save them that time of making that argument. A short amount of time, you're going to be back in the jury room, you're going to be deliberating. You're going to be asked to make a determination whether Hakeem Robinson is guilty or not. Again, to quote his daughter, hell no. Thank you.
All right, ladies and gentlemen, I'm going to give you a short bio break since we've been going for over an hour. So I'd ask that you leave your notepads behind, have a step into your jury room, and then we will return with the state's rebuttal and the court's instructions on the law. Thank you very much.
She said she gonna give him a short bio break. What up, family? Thank you all for joining. Shout out to you all for being here. I must have been on break. Some of y'all just coming in from break, huh? I see you. That's cool. I appreciate you joining, family. Let me see. We got some other stuff lined up. We can play on the side real quick. Y'all hit the like, hit the subscribe, tap in, share with a friend on your way in.
Welcome to Flesh of the God.
Well, isn't this a nice surprise?
Actually, what I'll do while they loading up, I'll play this what we missed earlier before I started, because I didn't start at the beginning, so there was some arguments in the beginning that we could start with while they on break.
The foreperson should see to it that your discussions are carried on in an organized way and that everyone has a fair chance to be heard. Whitaker Jr. or a principal intentionally committed an act or acts that caused the death of Charles McCormick Jr. Every person has a duty to act reasonably toward others. If there is a violation of that duty without any conscious intention to harm, that violation is negligence. The defendant cannot be guilty of manslaughter by committing a merely negligent act. In order to convict of manslaughter by act, it is not necessary for the state to prove that the defendant had an intent to cause death. Only an intent to commit an act that was not merely negligent and which caused death. As to count 2, to prove the crime of burglary, the state must prove the following 2 elements beyond a reasonable doubt.
Yes, sir.
And why were you concerned for Hakeem Robinson?
So I know that's they little friends circles, and he wasn't there. It was just them. Self-love first, right?
Over your children.
That's the law of nature. Love yourself first.
Welcome to Flesh of the God.
Well, isn't this a nice surprise?
I'm supposed to been dead. All this money on my head, I'm supposed to been dead. All this money on my head, I ain't never said.
Welcome, kings, queens, gods, human beings, and everything in between. The God Shango here. Today, we confront a chilling reality that forces us to question the very depths of loyalty and the dark deals made in the shadow of the justice system. The latest turn in the trial of Jacksonville rapper KSOO is a very clear display of survival at any and all costs.
Isn't it true that before you talked to the federal government, what you were facing back in 1999, you could have gotten up to life imprisonment, correct?
Yes.
And it was reduced to 10 years, right?
No.
Substantial reduction?
My time was reduced to 22 years.
How much did you serve?
About 10 years and 3 months, 4. Hakeem.
And that's Hakeem Robinson.
Yes, sir.
And why were you concerned for Hakeem Robinson?
So I know that's they little friends circles, and he wasn't there. It was just them. Self-love first, right?
Over your children.
That's the law of nature. Love yourself first.
What up, Tack Clouds, Miss D56, what up, Sweetie or Swede, what up, though, Indigo Kepra, what up, though, Jazzy T, Mookie, what up, I see y'all, appreciate y'all, let's get it.
Welcome to Flesh of the God.
Well, isn't this a nice surprise?
I ain't never stayed. I'm supposed to been dead. All this money on my head, I'm supposed to been dead. All this money on my head, I ain't never stayed.
Welcome, kings, queens, gods, human beings, and everything in between. The God Shango here. Today, we confront a chilling reality that forces us to question the very depths of loyalty and the dark deals made in the shadow of the justice system. The latest turn in the trial of Jacksonville rapper KSOO is a very clear display of survival at any and all costs.
Isn't it true that before you talked to the federal government, what you were facing back in 1999, you could have gotten up to life imprisonment, correct?
Yes.
And it was reduced to 10 years, right?
No.
Substantial reduction?
My time was reduced to 22 years.
How much did you serve?
About 10 years and 3 months, 4 months.
So from life to an ultimate actual serving sentence of about 10 years.
Yes, well, it was a law change, and that's how my time got reduced again.
Now let's talk about Darrell Watts. There's a bunch of cell phones that are in the name of Darrell Watts, right?
Correct.
Now, it's interesting, the government, they asked you about a bunch of phone numbers, and you remembered it off the top of your head, right?
Yeah.
Now, that phone's under your dead friend's name, Darrell Watts, right?
Right.
You paid for that phone, right?
Correct.
And in December, you paid something like $1,000 that you owed on that phone and others.
Right.
So whoever it is that had that phone, the shooter, you supplied it to him.
Oh, I didn't know the shooter had the phone. I didn't know.
Who is the person that was captured on the video recording shooting Charles McCormick?
My son,
What's your son's name?
Hakeem.
Did you hear that? The patriarch, Abdul Robinson Sr., known on the streets as Blue, stands on the witness stand, points directly at his own son, rapper KSOO, Hakeem Robinson, and names him as the shooter in the 2020 death of Charles McCormick Jr. This is not only a testimony, it's a son being thrown to the wolves by his own father.
So how is it that you know that he's a reliable hitman?
I mean, you hear things when you're in the streets.
And that's where you live?
I have been one.
All right, and the marks of that are on you. You have bullet holes, right?
Yes.
You have tattoos, right?
Yes.
Keem has neither.
Right.
Not a single tattoo on his body, right?
Right.
Never been shot.
That's good.
And when they brought you in, you've agreed to cooperate, right?
Right.
But that didn't happen until 2022, correct?
Right.
It ended up being the death of Mr. Rothermel and the attempt on P-Money, correct?
Correct.
But you have pled guilty to accessory after the fact for that death.
Yes.
And you have admitted to providing Varner
Yes.
with money in order to get out of town.
Ladies and gentlemen of the jury, I am going to show you the last photograph taken of Charles McCormick. I am showing you this photograph because that's what this trial is all about. It is about seeking justice for those brutally murdered. I show you this picture not to inflame your passions and make it so you find somebody guilty. I do it to specifically rebut a comment of defense counsel. Before we go into that offensive comment, I want to say this.
Objection to integration of counsel.
Overruled.
What I am commenting about the defense, I wholeheartedly believe in the Sixth Amendment of the United States Constitution and Mr. Robinson's right to have all the witnesses against him cross-examined by a zealous advocate, and that is what we did. My criticism is not that they have tried to do their job. My criticism is that the defense stood up after the young black man investigated by a black detective and tried to imply that this case is somehow about race. Somehow country singers or hard rockers don't get investigated. Only young black men who do rap songs do. And that's not true. Detective Smith poured out his life into this case for hundreds and hundreds of hours. And he didn't do it because of the race of the victim, and he didn't do it because of the race of the victim. He did it because Lady Justice is blind. This courtroom doesn't consider those things. This courtroom says that that bias cannot come into your decision-making. Judge Salvador will tell you as such. This is about whether or not the state has proven its charge beyond the exclusion of every reasonable doubt. And we embrace that verdict. It is not about young black men that rap, somehow us taking it out. Charles McCormick. You're going to hear a common theme throughout my rebuttal argument. Hakeem Robinson is either the unluckiest man who has ever lived on the face of the earth, or he's just plain guilty. The vast majority of the defense closing argument is about how an incredibly lucky piece of evidence, the dash cam video, somehow implicates that we have the wrong guy. That's been their defense since day one. Countless parts of his closing argument are about that. January 4th, January 14th, January 15th. It's not just about hairstyle underneath the hood. It's that he screams over and over and over again, 6'3", 230. And then we have the photographs that show it's just not true. It's just not true. We have digital laser scans that say it's 6'125". One of the reasons I'm showing you the two different views from Defense Exhibit 3 is to show how the light looks. There's 3, 2, 3. Because you have Hakeem Robinson. Months before, a couple days after, wearing identical, I see what it is. The evidence proves that's the same sweatsuit. You can tell just from that picture? No. But it's a pretty dang good piece of evidence. And the video God bless dash cams, surveillance videos, DNA. I've been doing this long enough that I remember when we didn't have all those things. And it's made our job a heck of a lot easier. And more importantly, it's made your job a heck of a lot easier. Because artful defense attorneys pounding their fist on tables, which they should do, their client. All of that doesn't change, and the picture can tell us 1,000 words. In this case, it tells us one. You're talking about slender, these poor witnesses. Okay, challenge number 1 from the defense. Get up here and explain why you didn't call witnesses that were working out in Bailey's and looking through glass. He said, what did he say? He said there's clean and dirty windows. Was Mr. Williams looking through a clean Bally's window or a dirty Bally's window when he was half a football field away with a guy crouching down? That his testimony to you doesn't help you make this decision because we have a video. The descriptions are totally irrelevant in this case. And then, they stand up here and argue. How dare we pay $70,000 to $90,000 for a paid extra? We're just buying our conviction. You know who deserved that? Hakeem Robinson deserved for the state of Florida to spend tens of thousands of dollars to figure out if all these descriptions, and mind you, they're not all. People that are closest put it right on more better descriptions. And when you look at the photographs of him at the time, he's much smaller than he is now. But regardless, we wanted to invest that money. The defense attorney gets up here and glares about how concerned he is with the government. Know that your government spent your money to make sure that all the corroborative evidence was right. that we could exclude Barner and Whitaker from that video. By the way, they match the description that everyone gives. We're going to put so much stock into these. They match it. And we invested that money to see. He's never going to be, no expert's going to be able to look at those and say they identify a particular human being. Does the body morphology. He says there's no way these two guys that match the description of the shooter given by people who admittedly don't know. And I'm guessing it's someone crouching after they watch a shooting for 2 seconds. He deserved that money. He deserved every penny of it. He gave that to you so you can have confidence. All the other evidence. Oh, little something, something. Talk about it's actually, it's been a long time. Cross-examining the medical examiner. Arguing about 5'9", 5'11". The doctor, in his report, in his measurement, says that the victim, Charles McCormick, by the way, that's his address where all their cell phones are made. It's not that. It's 5'10". Driver's license says it, medical officer says it, and the video shows that the shooter was bigger, wider, and tall. I wouldn't call it an insignificant amount, which perfectly matches the way Hakeem Robinson looked the day before, weeks before. Remember, this is the defendant next to Leroy Whitaker. You've had the opportunity to see them. Not a huge difference, is there? And we know that Leroy Whitaker is smaller than the victim. 40 minutes or so, we heard about it. The video proves our case. Now, of course, no one's asking you to look at that video and find the defendant guilty beyond a reasonable doubt. Because we're giving you so much more. A couple rules that Mr. Robinson or any aspiring young rapper should live by. If you're gonna brag or post about killing somebody, you probably shouldn't have DNA in the murder car or a fingerprint on the gun left behind in the murder car. If you're gonna post hoodie pictures of yourself singing and rapping in the weeks and months before and after, you probably shouldn't wear the black and tan hoodie to commit the murder. If you're going to have a burner phone, you probably shouldn't take selfies on it. If you're going to stake out a victim, you probably shouldn't get distracted and let him leave his apartment complex, so you have to follow him to a Merrill Road strip center where police officers are hanging out. And if you're going to pick co-defendants to do the case with, you probably should have done it alone. If you're going to get picked up by the girlfriend of one of your buddies, you probably should hope that she's ride or die, that she's not going to come to this court with no intimidation, with no cases hanging over her at the time she gave her sworn statement and here today, and say, that's who I picked up. And just for a second, before you think, well, maybe Hakeem Robinson, he's too smart to do that. Whoever did this killing, it includes Whitaker and Barner, they decided to go in broad daylight in a neighborhood, jump out and run through a strip mall and execute a human being for the whole world to see. The actions of a 21-year-old that gets excited and angry because he sees a person that has so disrespected his brother. dared utter these words.
Smoking on Whitley, Parker screaming out for help. Headshot instantly.
Put it in your blood. Shoot, we be smoking on with it. Picture to the left, rest in peace, brother, is posted less than 24 hours after the defendant took care of the person that spoke on Willie. There are very few people in the world, not exclusively this defendant, we've arrested a lot of them. A lot of them are charged, not all. A lot of them are charged. And there are others out there, but there aren't that many in ATK that had a motive to kill 6-block Little Buck. The greatest motive was Abdul Jr. Both defendants, Leroy Whitaker, and mind you, we tried these two cases together. All the evidence against Whitaker corroborates what Varner says, what the entire investigation leads to, and all of that evidence helps prove Robinson did. That's why we tried them together. So while you're not deciding Whitaker's case, you're going to have to know some of that evidence to know why Hakeem Robinson is guilty. And some of that is the phone records. But we have the opportunity by both defendants. Varner's admitted it. The opportunity by both defendants. Either the cell site is off or it puts them there. The defendant, by the defense's own admission, his known cell phone. Known cell phone. Now, 21 years old. I want to get the times right. He has his cell phone powered off for the exact amount of time it takes to do this case, to do this crime. When his cousin and friend, overwhelming evidence, also overwhelming on him, when they're doing this crime, it just happens to be powered off. And the defense, I submit to you, was trying to show that the data on the phone, because you see there it's data, and this is the situation where the FBI analyst was unwilling to map the data sessions. Between those two times, nothing going on while his phone's turned up. Remember the cross-examination of the expert over and over again? He was on a boat. He was, no, your smartphone is on. It's getting data. Even if it's not connecting to a tower, it'll show data usage. Said that. They kind of followed that. But when we plotted the data usage, which the FBI was unwilling to do on their own because of the errors, 95% accurate, I think 95 to 98% accurate. You know what that data usage, so this is when we did the Google Maps stuff and we put in the coordinates. When we did that, his known phone, his admitted phone, was in two really important places before it got powered down. Remember those Google Earth pictures? It was one picking up Barner off of University, Spring Park. We saw that map. Then it was off Atlantic Boulevard, which is exactly what Dominic Barner said they went to pick up the Impala. Excuse me, the Nissan, to commit this crime. In an apartment complex off Atlantic Boulevard. His phone, known phone, was in those two locations, just like Barner said. And those were never mapped. Barner couldn't have been fed the information by the state. You do that in a court live. Go in the hole, just like he said, like Barner said. So the other phone records show that you can see the red is going to be Mr. Robinson's burner phone, the phone that he takes selfies on, that Hakeem Robinson got in his dead friend's name that he handed him, that existed for about 2 months. On this particular occasion, Mr. Robinson thought that burner phone would never be tied to him because his real phone was turned off. And by the way, the whole selfie thing, and he never said, dads don't call their sons on their burner phones. Dads call their sons on their real phones. The burner phone is when you do dirt. So, he's hitting off the Merrill Road Tower shortly before the crime. The arrow points that he is going in the vicinity of Townsend Boulevard. This is you see the arrows, the red arrows, and then the 7201 Arlington, and the defendant's burner phone is going in those directions, and you can see the data usage in the green box to the right of all the little arrows. It is going in the direction of where he is picked up. This is his burner phone. His real phone is turned off. And then we find that it's going in the right direction. We find the cache. He deleted all this, by the way. But this was found in the cache. He didn't know about that. Off the burner phone cloud, the phone's gone. On the burner phone cloud, we find the pin drop in the location of the nature preserve. You can kind of see it cut off, the nature preserve, the tree hill on the right side. That is just, I don't know, maybe 100 yards, Lillian Road, Lone Star. That's just a little bit north of where he was picked up by Natalie Gann. Not the exact location, it's just a little bit north. And then we have the path he came through the tree hill. Nature preserve, where Renata Boston identified a person in a black and tan sweatsuit. Just the unluckiest man on the face of the earth. What was he just doing? Identifies a black and tan sweatsuit coming out of the woods. I think he's a nature lover. And then Natalie Gann picks him up. Says a white girl carrying a phone. Mention the IP address. The defense makes a big deal about Smith not being an expert because the IP address helps prove that the burner phone is Hakeem Robinson's burner phone because of the IP address. The T-Mobile records, some of which you'll have in there, if you care to look at it, actually in some of the instructions, not all, but in some of the instructions in the records, the top line says the IP address, only the first four numbers should be considered. It's not. The records that we have introduced in this case tell you it's just the first four numbers. It's not just Smith. That's just a side note. So we have them all together, meaning back safe on Brown Jersey Court, Hakeem, Kareem, and Barner, and Whitaker. Look at that. And this is, magically, the defendant's real phone turns back on when they're safe. Objective known truths. We know that Nissan is the murder car. We know the shooter fled with the murder weapon. It's described perfectly. There is no murder weapon in the car. The murderer fled with the murder weapon. We know this as an absolute fact. Robinson is linked to the murder car in 3 different ways. The shirt, the driver's compartment swab, and the print on the firearm. Here's where the defendant, mind you, they spent 2 minutes talking about the DNA because it's not good for their case. I get it. But here's where their argument about transfer fails. Look at the way that shirt is. It's rolled up. Think back to what the DNA analyst said. I took swabs at the wearer, the neck, and the underarm. Not just in the middle of the shirt that's balled up in between the seat. And somehow, their argument is that this balled up shirt, wrapped up shirt that has wearer DNA of the defendant, oh, by the way, and you are of the defendant, somehow that jumped off of the shirt and got in the driver's compartment and was balled up in the corner of the seat. Maybe he's the unluckiest person on the face of the earth. Maybe he's just guilty. Oh, and there's prints on the slide of the firearm. It's right next to the shirt that has his new on the Maybe you shouldn't be bragging about killing Willie with that evidence. I mean, killing Willie's killer. And bragged about killing Willie. Incredibly powerful evidence. No chance that could be tampered with. Remember, they sealed the vehicle. It's the way it was when all three of them jumped out because they decided to commit a murder right in front of the police. And we were able to catch them. Whitaker's in the car 2 ways. He's on both shirts. We have those shirts. Robinson possessed a similar and unique firearm before the crime. This was kind of just glossed over. But we did pay a lot of money. And in addition to this defendant deserving that, digital expert Latham provided another service. Firearm in this defendant's hand just a few weeks before this murder. And he is celebrating it on the Bang It Up music video. Is the same type of firearm. And according to Barner's testimony, is the same type. We hear from the FDLE firearms expert, right? This is the first FDLE person called. The manufacturer of that firearm discontinued. And although there are other models like it, there aren't that many of them. This isn't a Glock 9mm or a Glock. This is some common firearm that everyone in the world has. This is a relatively, I don't want to oversell it, I'm sure there's guns out there. This is a relatively unique firearm.
Objection, Your Honor, mischaracterization of the testimony.
Overruled.
You rely upon what the expert in this Amherst said. No longer manufacture that kind of gun. Companies go out of business. It's usually because you don't sell a lot of the gun. Sell a lot of the gun, you usually keep making them. Right? AR-15 is real popular. Keep selling them. Okay. Enough on that. Barner and Whitaker were so desperate to get away that they assaulted Miss Buckley and left their DNA on her pajamas. Again, it shows that they were all in for a penny, in for a pound. And that proof corroborates Barner, corroborates Blue, who picked up these two guys after they assaulted Miss Buckley. And you heard all that testimony. Whitaker and Barner got picked up by Blue. We know that that's a fact. These are objective truths. You don't need to assess credibility. Robinson is right-handed. Fact. Shooter was, guess what? Right-handed. Does that prove he did it? No, but it's a nice fact to know, isn't it? He was worn, and he has worn a black and gray hoodie just like the shooter has worn. When you combine all of these things, you are narrowing the scope beyond just the exclusion of every reason. We are not eliminating every conceivable possibility. We are not eliminating all of them. Well, I said it to you, we have. But the proof here is beyond to the exclusion of every logical, well-founded, reasonable doubt that any logical person could have about whether we got the right guy. Robinson was real happy about the defense wants you to think that he's arrested because of this post. Sergeant Smith has his fingerprint on a pistol in the driver's seat console, like in between the seat and the console. Water. With his print on the slide.
Okay.
It's in between the seat and the console. He has his print. And that's the post he sees. It's context. You know, they said, we're going to explain the context of all that. That's the context. Context is, Smith goes, holy cow, the guy's bragging about it. The kind of person that would brag about this is the same person that would go out, narrow road, 1058, and gun down another human being in front of everyone in the world and the dash cam to see. Same type of person. The video proves the descriptions were wrong. It proves it. We called the witnesses that were able to provide meaningful testimony, not the witnesses that were working out on the elliptical and looking through glass. For them to say, I guessed, and none of them were sure, I guessed about the person, and the video proves me wrong. Spent a little bit of time talking about Barner. He is a murderer. I don't like him. Defense has a good time. He got beat up twice by two very seasoned, experienced defense lawyers. It's hard to sit there and listen to them beat him up. Fine. We expected that because he deserves it. The reprehensible deal they turned around and screamed at the state of Florida for was we got a convicted murderer to subject himself willingly his own free will to have Judge Salvador sentence him to life without the possibility of parole. And the only benefit that we gave him is you get to testify, show your remorse, stare at the face of your community, your friend, and do what's right for Charles Court. If you do that, the judge can consider it and do anything she wants, including giving your life. For 50 or 45 years. And he knows that. And there's nothing he can do about it. I wish all prosecutors were that unsuccessful in convicting murderers. Lou is looking at 20 years. He's a middle-aged, 50-something-year-old guy, 55 I think he is, with diabetes and kidney failure. Not very different from the deal worked out for Barner. All witnesses meet. It is entirely proper for witnesses to meet with us. The defense wants to say, well, I'm not going to argue they shouldn't meet with their witnesses, but they shouldn't meet with their witnesses unrecorded. Scenario. Dominique Barner, you're going to plead guilty and subject yourself to life. The lawyer is here. We need to make sure this is something you really want to do, because once you give this sworn statement, there's no going back. You're going to be under oath. We're going to sit down and make sure that this is something that you're going to be willing to do before we go on the record. you're staring at your friends, your community, your family, and you're turning into the one thing that you swore you would never be. Snitch. Are you sure you want to do this? Yeah? Is this what you're going to testify to? Yeah? All right, we're on the record and we're putting you under oath. Oh, how dare the government do this? A pre-meeting is somehow evil? This is what they're arguing. No witness should be discredited for talking to a lawyer about his or her testimony. Arner wants the absolute best deal for himself. No doubt about that. He said it over and over again. So his plan, according to the defense, is to lie to the people who will recommend a sentence to the judge and lie in front of the judge that's going to sentence him. What if, over years and years, we find out that he's lying to us about the facts of the case? Remember the DNA evidence didn't come back? It was until mid-2022?
He said, what if over years and years? But he'd be out in years and years. He ain't gonna be worried about that. Talk about years. My bad. I had to cut it.
All that cell phone, all that Instagram, that stuff's just pouring in. And we're going through it up until shortly before trial we're pouring through. And somehow he's going to make the decision, I'm going to subject myself to life, knowing she can give me life, knowing the state will make a recommendation. I'm going to lie to these people about who's with me? The defense challenged me to say, why on earth did they say that part of the deal was I had to implicate my son or my good friend? And they said, yeah, if I say it's anybody else, the deal's not there. Because it's the truth. And if they say somebody else besides the person that did it, then of course there's no deal. Because they're committing perjury. Evidence doesn't show anybody else. The one little piece of evidence that shows somebody else, sort of, is this Chris guy whose hair, not skin cells or blood or anything like that, whose hair, which is much more easily transferable, and he lived and hung out with the people living in that Brown Jersey courthouse. I don't know if he lived there, but he certainly was there. The testimony was from Abdul Robinson, was he was there all the time, and his baby mama lived there. But he was there all the time, and that little piece of hair was there. So what did the detective do? Pull his cell phone records. Let's see where this guy is, even though there's no implication he's an ATK or any of that stuff, or has any motive to do any of this. But they go pull it, and he's across town. You know, one of the jurors said in jury selection, trust but verify. And that is exactly what you have seen here today. You don't have to trust every word Dominique Barner says unless you verify it. Even the defense had to admit. If you caught me smirking, it was when I heard this. The defense had to admit that Barner got his facts straight. Yeah, he did. He did get his facts straight. Trust but verify. Barner had no idea the person he said he picked him up was going to testify and agree to that. He didn't know that. He gave a sworn statement. How was he supposed to know that? Barner doesn't know that Natalie Gatton and Nada Boston were here to testify. I need to reset here because this video evidence that we had in our first slide, it shows how the defendant looked leading up to this crime, combined with him wearing the sweatsuit and then a picture of the shooter. That piece of evidence, combined with Renata Boston and Natalie Gatton, you don't need DNA, you don't need Barner. That evidence in and of itself is enough to convince any reasonable jury that he got it right. So when you combine all the pieces of evidence, we have a guy in a black and tan hoodie murdering Charles McCormick, running into the murder car, jumping out of the murder car with the same gun, running and jumping fences. And by the way, thanks for the video when you toggle. I'm not going to talk about that much more. I appreciate it. We did it. It certainly seems like the police officer is a little bit taller than the shooter. Anyway, jumping fences, doing all those things. One more thing about the sprinting. You see the video, we played a little bit of it, and God bless police officers who chase after gunfire. They have to put on a bulletproof vest to go to work. But he was coming out of Publix off duty. The whole body cam, he's not prepared to work that day, he's off duty. He didn't
Objection,
have the body
mischaracterization
cam.
of testimony, he was on duty.
Overruled.
The absence of evidence is not the evidence of absence.
What?
Big shout out to Sweet Tea. I love your channel. Appreciate the support. Much needed break because he was kind of drying me out. I ain't gonna be too long. We gonna get right back into it. But geez, he dry as hell. But shout out to Sweet Tea. Y'all show her some love. Drop her some coins in the chat. Appreciate you, family.
Well, you remember, don't mind me, it doesn't really matter, that he was so cautious when he was looking for me to walk by that car. I think he sprinted by that car. Officer Collins walked kind of slowly, looking around because he knows, and he said it, someone could be sitting there ready to ambush him, and he saw that guy with a rifle. He wasn't chasing after him full bore, that's idiotic. That's how he got away. Out of Boston says, after I get a text alert, it takes a long time to get rid of the defendant got all the way through that woods and get rid of the burner phone and the rifle. Get rid of those things. He comes out of the woods wearing a hoodie by himself. And she goes, I'm getting out of here. And I did notice a girl, a white girl with a phone. Let's be very, very clear about this. Natalie Gann came in and gave her sworn statement. She was a free woman, and everyone she loved and cared about. Her husband getting arrested subsequently is irrelevant. She had already given her sworn statement. These are not people, as the defense characterizes, coming in chains by the state's leash. And all of the eyelash comments the defense can make about her doesn't change the fact that she was a rock on that witness stand. She said, I used to date tour guy. I know all these guys. They weren't going to go up there and pick this guy up. They told me, the white girl, we're going to pick up this guy. And if we're trying to strong arm her to testify, why doesn't she say he was wearing a black and tan hoodie? As opposed to the truth, which is, I don't remember what he was wearing. It was a beanie. And that's what the Out of Boston combination with Natalie Gann is proof beyond a reasonable doubt. I think the identity of the person that executed Charles Manson. Forget the DNA, forget the prints, forget the brand, forget Barlow, forget Blue. Combine it all. That's where you get beyond the reasonable doubt. You have that abiding conviction and guilt. You can be confident in your word, and that's where we get beyond all possible doubt, which is God. Dominic Barner may be a liar. He's not lying. He couldn't know the digital expert Latham was going to analyze the body morphology and conclude the defendant could be the person behind the mask. How did he know that? No idea. And by the way, you have to combine that with the knowledge that Dominic Barner has given his life over to Judge Salvador in the state of Florida as an defense capacity. He's given his life over to us. You better be right when he tells us you did this. Because the body morphology will prove it. He's lying. He won. Barner had no idea that we would be able to link Whitaker's phone on Instagram. That Instagram for Whitaker is the verification number on his Instagram records. And when he on Instagram says, this is my phone number, ding, 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 we were able to link it to Whitaker. They don't, it's not registered to him. But he says, this is my number on Instagram. And it proves, that phone proves the location every single step of the way that Whitaker is at with Barner. Step in for a penny, in for a pound. And Barner had no idea that the cloud would capture proof of Robinson's burner phone was his, and they could link him to the murder. He had no idea of he couldn't fabricate DNA and print evidence. He did not know that Robinson's known cell phone was turned off during the murder. The phone data of the known phone would be hitting off his apartment and the pickup for the Nissan. Well, how does he know that? Look at how street smart you are. It's going to be hard for y'all. It was hard for us. Mr. Cooper and Mr. Atkinson are much better at it than I am. I struggle with this stuff. And Dominic Barner's going to do it? It just means he's telling the truth. That's all it means. The defense challenged the state on a number of different things, and each and every one of those we easily rebutted. Not a Boston never said shoulder length dreads. She said dreads to the chin, which if it's sticking out of a hoodie, that's about where it is. Defense argues things like, I'm not saying that Chris Brown did it. Look at the video, you'll see the defendant's hand. You'll see Hakeem Robinson's hand and compare that to his complexion. It's the same. Not to mention all the autographs. There's no DNA transfer. The defendant was in that car, jumped over the center console, which is where his touch DNA came from, and the shirts and the guns that he'd already handled, and jumped out and was so excited that he didn't wait for his backup. $700 billion to 1 chance that someone other than the defendant is on that shirt. 4.4 million to 1 chance that this defendant's touch DNA is on the driver's area. He's either the unluckiest man on the face of the earth, or he's just plain. No matter how many times you pound on the table, scream 6'3", 230, we have the video evidence to prove that's just not true. And then, once you know you have that abiding conviction of guilt, the job is yours to find the truth in this case. The dead, they can't call out for justice. It's up to us, the living, to seek it on their behalf. Nothing that we do here can change the lives of that poor family. He will be dead forever, and the last known photograph of him will be on the slab in the medical examiner's office. But what your verdict can do is forever define who did this. It is inescapable. KSOO Robinson is the man behind the mask. It's been proven to you 700 ways. We trust that you will uphold your duty and find this defendant.
All right, thank you, Mr. Mizrahi. All right, members of the jury, you have now heard and seen all the evidence which will be introduced in this case, and you have now listened carefully to the arguments of the attorneys. And I'm now going to direct your attention to the jury instructions, which I'm required to give you, which I remind you, you are required to follow. For your convenience, the jury instructions are going to appear on the monitors before you so that you can easily follow along as I read them to you. In addition, I'm going to be sending in one hard copy of the instructions to the jury room for your use during deliberations. So let's make sure that your monitors are on and working. Yes? All right, very good. All right, let us begin. And I would ask any members of the gallery, if you wish to leave now, you may do so, but once the instructions begin, I don't want people coming in or out, that would cause a distraction, excuse me. All right, thank you. All right, members of the jury, I thank you for your attention during this trial. Please pay attention to the instructions I'm about to give you. Hakeem Robinson has been accused of the crime of murder in the first degree. In this case, Hakeem Robinson has been accused of first-degree murder. Murder in the first degree includes the lesser crimes of murder in the second degree and manslaughter, all of which are unlawful. I now instruct you on the circumstances that must be proved before Hakeem Robinson may be found guilty of murder in the first degree or any lesser included crime. As to count one, to prove the crime of first-degree premeditated murder, the state must prove the following three elements beyond a reasonable doubt. Number one, Charles McCormick Jr. is dead. Number two, the death was caused by the criminal act of Hakeem Robinson. Number three, there was a premeditated killing of Charles McCormick Jr. by Hakeem Robinson. An act includes a series of related actions arising from and performed pursuant to a single design or purpose. Killing with premeditation is killing after consciously deciding to do so. The decision must be present in the mind at the time of the killing. The law does not fix the exact period of time that must pass between the formation of the premeditated intent to kill and the killing. The period of time must be long enough to allow reflection by the defendant. The premeditated intent to kill must be formed before the killing. The question of premeditation is a question of fact to be determined by you from the evidence. It will be sufficient proof of premeditation if the circumstances of the killing and the conduct of the accused convince you beyond a reasonable doubt of the existence of premeditation at the time of the killing. In considering the evidence, you should consider the possibility that although the evidence may not convince you that the defendant committed the main crime of which he is accused, there may be evidence that he committed other acts that would constitute a lesser included crime. Therefore, if you decide that the main accusation has not been proven beyond a reasonable doubt, you will next need to decide if the defendant is guilty of any lesser included crime. The lesser crimes indicated in the definition of first-degree murder are second-degree murder and manslaughter. As to count one, to prove the lesser included crime of second-degree murder, the state must prove the following three elements beyond a reasonable doubt. Number one, Charles McCormick Jr. is dead. Number two, the death was caused by the criminal act of Hakeem Robinson. Number three, there was an unlawful killing of Charles McCormick Jr. by an act imminently dangerous to another and demonstrating a depraved mind without regard for human life. An act includes a series of related actions arising from and performed pursuant to a single design or purpose. An act is imminently dangerous to another and demonstrating a depraved mind if it is an act or series of acts that, number one, a person of ordinary judgment would know is reasonably certain to kill or do serious bodily injury to another, and number two, is done from ill will, hatred, spite, or an evil intent. And number three, is of such a nature that the act itself indicates an indifference to human life. In order to convict of second-degree murder, it is not necessary for the state to prove the defendant had an intent to cause death. As to count one, to prove the lesser included crime of manslaughter, the state must prove the following two elements beyond a reasonable doubt. Number 1, Charles McCormick Jr. is dead. Number 2, Hakeem Robinson intentionally committed an act or acts that caused the death of Charles McCormick Jr. Every person has a duty to act reasonably toward others. If there is a violation of that duty without any conscious intention to harm, that violation is negligence. The defendant cannot be guilty of manslaughter by committing a merely negligent act. In order to convict of manslaughter by act, it is not necessary for the state to prove that the defendant had an intent to cause death, only an intent to commit an act that was not merely negligent and which caused death. The state must prove the crime was committed on January 15 of 2020. It must be proved only to a reasonable certainty that the alleged crime was committed in Duval County. The defendant has entered a plea of not guilty. This means you must presume or believe the defendant is innocent. The presumption stays with the defendant as to each material allegation in the indictment through each stage of the trial, unless it has been overcome by the evidence to the exclusion of and beyond a reasonable doubt. To overcome the defendant's presumption of innocence, the state has the burden of proving the crime with which the defendant is charged was committed, and the defendant is the person who committed the crime. The defendant is not required to present evidence or prove anything. Whenever the words reasonable doubt are used, you must consider the following. Proof beyond a reasonable doubt does not mean proof beyond all doubt. A reasonable doubt is not a mere possible doubt, a speculative, imaginary, or forced doubt. Such a doubt must not influence you to return a verdict of not guilty if you have an abiding conviction of guilt. On the other hand, if after carefully considering, comparing, and weighing all the evidence, there is not an abiding conviction of guilt, or if having a conviction, it is one which is not stable but one which wavers and vacillates, then the charge is not proved beyond every reasonable doubt, and you must find the defendant not guilty because the doubt is reasonable. It is to the evidence introduced in this trial and to it alone that you are to look for that proof. A reasonable doubt as to the guilt of the defendant may arise from the evidence, conflict in the evidence, or the lack of evidence. If you have a reasonable doubt, you should find the defendant not guilty. If you have no reasonable doubt, you should find the defendant guilty. It is up to you to decide what evidence is reliable. You should use your common sense in deciding which is the best evidence and which evidence should not be relied upon in considering your verdict. You may find some of the evidence not reliable or less reliable than other evidence. You should consider how the witnesses acted as well as what they said. Some things you should consider are, number 1, did the witness seem to have an opportunity to see and know the things about which the witness testified? Number 2, did the witness seem to have an accurate memory? Number 3, was the witness honest and straightforward in answering the attorney's questions? Number 4, did the witness have some interest in how the case should be decided? Number 5, does the witness's testimony agree with the other testimony and other evidence in the case? Number 6, has the witness been offered or received any money, preferred treatment, or other benefit in order to get the witness to testify? Number 7, has any pressure or threat been used against the witness that affected the truth of the witness's testimony? Number 8, did the witness at some other time make a statement that is inconsistent with the testimony he gave in court? Number 9, has the witness been convicted of a felony? Whether the state has met its burden of proof does not depend upon the number of witnesses it has called or upon the number of exhibits it has offered, but instead upon the nature and quality of the evidence presented. The fact that a witness is employed in law enforcement does not mean that his or her testimony deserves more or less consideration than that of any other witness. Expert witnesses are like other witnesses with one exception. The law permits an expert witness to give his or her opinion. However, an expert's opinion is reliable only when given on a subject about which you believe him or her to be an expert. Like other witnesses, you may believe or disbelieve all or any part of an expert's testimony. You must consider the testimony of some witnesses with more caution than others. For example, a witness who claims to have helped the defendant commit a crime or has been promised immunity from prosecution or hopes to gain more favorable treatment in his or her own case may have a reason to make a false statement in order to strike a good bargain with the state. This is particularly true when there is no other evidence tending to agree with what the witness says about the defendant. So while a witness of that kind may be entirely truthful when testifying, you should consider his or her testimony with more caution than the testimony of other witnesses. However, if the testimony of such a witness convinces you beyond a reasonable doubt of the defendant's guilt, or the other evidence in the case does so, then you should find the defendant guilty. It is entirely proper for a lawyer to talk to a witness about what testimony the witness would give if called to the courtroom. The witness should not be discredited by talking to a lawyer about his testimony. You may rely upon your own conclusion about the credibility of any witness. A juror may believe or disbelieve all or any part of the evidence or the testimony of any witness. The Constitution requires the state to prove its accusations against the defendant. It is not necessary for the defendant to disprove anything, nor is the defendant required to prove his innocence. It is up to the state to prove the defendant's guilt by evidence. The defendant exercised a fundamental right by choosing not to be a witness in this case. You must not view this as an admission of guilt or be influenced in any way by his decision. No juror should ever be concerned that the defendant did or did not take the witness stand to give testimony in the case. Now, these are some general rules that apply to your discussion. You must follow these rules in order to return a lawful verdict. Number one, you must follow the law as it is set out in these instructions. If you fail to follow the law, your verdict will be a miscarriage of justice. There is no reason for failing to follow the law in this case. All of us are depending upon you to make a wise and legal decision in this matter. Number two, this case must be decided only upon the evidence that you have heard from the testimony of the witnesses and have seen in the form of the exhibits in evidence and these instructions. Number three, this case must not be decided for or against anyone because you feel sorry for anyone or are angry at anyone. Number four, remember the lawyers are not on trial. Your feelings about them should not influence your decision in this case. Number five, your duty is to determine if the defendant has been proven guilty or not in accord with the law. It is the judge's job to determine a proper sentence if the defendant is found guilty. Number six, whatever verdict you render must be unanimous. That is, each juror must agree to the same verdict. Number seven, your verdict should not be influenced by feelings of prejudice, bias, or sympathy. Number eight, your verdict must be based on the evidence and on the law contained in these instructions. Deciding a verdict is exclusively your job. I cannot participate in that decision in any way. Please disregard anything I may have said or done that made you think I preferred one verdict over another. Now, during this trial, I have permitted you to take notes. You will be allowed to take those notes into the jury room during deliberations. You are instructed that your notes are a tool to aid your individual memory. You should not compare your notes with the notes of other jurors in determining the content of any testimony or in evaluating the importance of any evidence. Notes are for the note-taker's personal use in refreshing his or her recollection of the evidence. They are not evidence. Above all, your memory should be your greatest asset in your recollection of the evidence. You may find the defendant guilty as charged in the indictment or guilty of such lesser included crime as the evidence may justify, or not guilty. If you return a verdict of guilty, it should be for the highest offense which has been proven beyond a reasonable doubt. If you find that no offense has been proven beyond a reasonable doubt, then of course your verdict must be not guilty. The verdict must be unanimous. That is, all of you must agree to the same verdict. Only one verdict may be returned as to the crime charged. The verdict must be in writing, and for your convenience, the necessary verdict form has been prepared for you. And it will be on the screen, but I'm also holding in my hand the one-page verdict that is styled State of Florida versus...
The absence of evidence is not the evidence.
Real quick, I ain't gonna take too long. Gotta show some love to Taylor Umbridge. I know you streaming live too, so I want to catch you right here. Appreciate the support, family. Y'all show Taylor Umbridge some love. Drop her some TUs in the chat. Show her some love. And also TSC also dropped a little bit, so I appreciate you. We gonna get right back into it. I ain't gonna interrupt too long. I just want to show them some love real quick. Appreciate you, family.
Hakeem Robinson, titled Verdict Count 1. You have 4 verdict options, and they read as follows. The first one is, we, the jury, find the defendant guilty of first-degree murder as charged in the indictment. If that is your unanimous verdict, you mark that line with an X or a check. The second verdict option reads, we, the jury, find the defendant guilty of second-degree murder, a lesser-included offense. If that is your unanimous verdict, you mark that line. The third option reads, we, the jury, find the defendant guilty of manslaughter, a lesser-included offense. If that is your unanimous verdict, you would mark that line. And we, the jury, find the defendant not guilty. If that is your unanimous verdict, you would mark that line. So say we all, done at Jacksonville, Duval County, Florida, and there's a line for the foreperson to sign and date the verdict form. In just a few moments, you will be taken to the jury room by the bailiff. The first thing you should do is choose a foreperson who will preside over your deliberations. The foreperson should see to it that your discussions are carried on in an organized way and that everyone has a fair chance to be heard. It is also the foreperson's job to sign and date the verdict form when all of you have agreed on a verdict, and to bring that verdict form back to the courtroom when you return. During deliberations, jurors must communicate about the case only with one another and only when all jurors are present in the jury room. You are not to communicate with any person outside the jury about this case. Until you have reached a verdict, you must not talk about this case in person or through the telephone, writing, or any electronic communications such as a blog, Twitter, email, text message, or any other means. Do not contact anyone to assist you during deliberations. These communication rules apply until I discharge you at the end of the case. If you become aware of any violation of these instructions or any other instruction I have given in this case, you must tell me by giving a note to the bailiff. If you need to communicate with me, send a note through the bailiff signed by the foreperson. And if you have voted, do not disclose the actual vote in the note. If you have questions, I will talk with the attorneys before I answer, so it may take some time. You may continue your deliberations while you wait for my answer. I will answer any questions, if I can, either in writing or orally here in open court. Now, during the trial, items were received into evidence as exhibits. You may examine whatever exhibits you think will help you in your deliberations. These exhibits will be sent into the jury room with you when you begin to deliberate. In closing, let me remind you that it is important that you follow the law spelled out in these instructions in deciding your verdict. There are no other laws that apply to this case. Even if you do not like the laws that must be applied, you must use them. For 2 centuries, we have lived by the Constitution and the law. No juror has the right to violate the rules we all share. So, ladies and gentlemen, that will conclude the instructions. At this time, I will allow you to take your notes, 1 hard copy of these instructions, the verdict form, and all of the exhibits into evidence back into the jury room for you all to begin your deliberations. And as we discussed yesterday, this will be a working lunch. Of course, you can eat lunch in the jury room. And that will be all of you, with the exception of jurors number 13 and 14. I don't know, ladies, if you all knew that you were the alternates in this case. We generally don't share that information with our jurors prior to this point, but that means you will not be deliberating with the rest of the jurors in this matter. Now, before I excuse you, do you have any personal items that you need to retrieve from the jury room? Okay, if you both could quickly go with the bailiff to retrieve those things, come back out here as I'll have some final parting instructions for you. And the rest of you, ladies and gentlemen, if you don't mind just patiently waiting until they return. You may go now.
Yo, real quick, shout out to Taylor Unbridge again. She's also streaming. She's been streaming this whole trial, so if you want to see all the whole thing, she got it on her channel. Shout out to her. Appreciate you for the support. And shout out to Chad My Black is Golden coming through with
The absence of evidence is not the evidence of absence.
What?
Appreciate you. So now we know that they going out for verdict, right? So that's all I'm gonna stream for now, but I'll come back maybe tonight and I'll play the verdict. So I'm sure everybody gonna already know what it is by the time I come, but I was real quiet. There was a lot of stuff I wanted to say, so I'm gonna try to come back tonight and drop another one where I'm talking a little bit more about how I feel about some of them parts. Maybe I'll clip out some of the parts that was important to me, and we talk about it tonight. And also the verdict too, with the verdict reading too. That should be there tonight. But I appreciate y'all being here. Oh, actually, I ain't gonna wrap it up yet. I'm gonna play the last bit of that video I was playing first, and then I'm gonna wrap it up. But I appreciate all y'all being here. Much love, much love. Shout out to our stream sponsors of the day. And let's keep it rolling. We almost up out of here. I want to finish this before I go, though. What's this? Right here. Boom, right here. Let's get it.
Correct?
Yes.
There was a point in time when these two murder cases are pending that you learned that the government is now trying to leverage you, threatening you with charging you as a principal in the Rothermill case, right?
Yes.
And that would have meant a life minimum mandatory for you, right?
Yes.
Prosecutors claim KSOO sought revenge for a family member killed in a drive-by, but the defense immediately fired back, exposing Bloom's own dark history. A career informant, as they called him, a man known to take deals to lighten his own sentences. They argue Blue himself has more motive than KSOO.
So, you agree, you cave, and astonishingly for the second time, why is it that you only grow a conscience when you're looking at hefty prison terms? Right?
Right.
You had to cooperate and implicate your two sons, but it got you out of custody.
You say implicate them?
You had to point at your sons. Let's back up for a second. At the point in time that they leverage you with life on the Rothermill case, they had already arrested your son and said that he was the one that committed it, right?
Oh, no, you confusing me.
Let's break it down. You said a moment ago that the government sent a message to you that they were going to basically indict you on the Rothermill case and that you were potentially looking at life. You then decided to cooperate. You remember that, right?
Right.
Okay. He was murdered.
Yeah.
To this day, you were not cleared as a suspect in that case.
Sustained.
And are you telling me that you, as the patriarch of the family, and basically these kids come by and say, hey, Blue, go do this?
They didn't call Leroy Whitaker daddy to go do it. They called me. What if they would have called I would like to see how they would feel if they would have called somebody else to go pick somebody up. They didn't. They called me.
But why this ultimate betrayal? Well, Blue is facing 2 serious charges that can land him in prison for life. He's testifying against his own flesh and blood, hoping for a lighter sentence. He speaks of health issues, having 2 6-year-olds and an 8-year-old daughter, admitting that this is only part of the reason he's sending his son to potentially face life behind bars.
If I would have knew something was going on, I wouldn't have never went. Then I'm gonna go over there in my car with my phone and knowing something going on. If I would like to have been involved in a crime, I'd like to know that I'm involved in a crime. Let me know that, okay, there's a crime happening now. Let me know something. I was in the blind.
So you're a victim in this case, right?
This is the agonizing but brutal truth of how the system can operate. It's not always pure justice. Sometimes it's about forcing an unholy bargain, twisting family bonds until they break, all in the name of a conviction.
Well, Jacksonville rapper KSOO took another dramatic turn when his own father took the stand to testify against him this afternoon. Hakeem Robinson, also known as KSOO, and his cousin Leroy Whitaker Jr. are both charged in the 2020 shooting death of 23-year-old Charles McCormick Jr. Prosecutors say Robinson wanted to kill McCormick, known as rapper Buck, for making a diss track about someone in his family who had been killed in a drive-by shooting.
According to Abdul Robinson Sr., it was Hakeem Robinson who killed McCormick for revenge.
What kind of justice demands such a sacrifice? What desperate choices are people forced to make when facing the system's crushing weight?
Who is the person that was captured on the video recording shooting Charles McCormick?
My son.
What's your son's name?
Hakeem.
Looking at his son in the eyes as he named him as the shooter in the death of McCormick. However, the defense quickly fired back, stating Blue has a career of being an informant and to testify to take deals to lighten his sentence and that it was him with more of the motive. Abdul Robinson Sr., known on the streets as Blue, took the stand Monday, pointing out his son, rapper Hakeem Robinson, also known as KSOO. Now, Blue is facing 2 serious charges of his own that could land him in prison for life, but he's testifying against his son, hoping for a lighter sentence.
I got some health issues. I got 2 6-year-olds and an 8-year-old daughter.
Blue says this is only part of the reason why he's testifying against his son.
Well, we got to keep taking these deep dives and looking at these moments with a microscopic lens. Keep your third eye open and watch the true nature of the powers that seek to control and divide us. Remember that. Stay vigilant, stay fresh, and stay blessed. Peace out, family. Hit that like and subscribe on your way out. Much love. Peace out.
Let's keep it real. Everyone needs to go to jail. I'm sorry, but everyone on this whole beef needs to be locked up. You know, it's really unfortunate. Bad things have happened on both sides, but as a society, we can't have you running in people's houses taking hostages. It's just not happening. We're not allowing that.
Oh, it was they call it the story. It's on the story saying to kill a nigga and get his toes done.
Shout out to everybody in the chat. What up, FFS? I see you, family. Tat Clouds, what up, tat, tat, tat. Chan My Black is Golden. Shout out to all the stream sponsors.
The absence of evidence is not the evidence of absence.
Y'all drop some coins for the stream sponsors. Tia C, Chan My Black is Golden, Sweet T, Taylor Umbridge. Y'all go sub up to Taylor Umbridge. I just dropped her link in the chat here. Let me drop it one more time. Boom. Go sub up to Taylor Umbridge. She got the whole trial coverage locked down. Appreciate you. Much love. Yo, Sweetie. Shout out to Sweetie or Swede. I didn't get it yet. Is it Sweetie or Swede? I don't know. But shout out to Swede. Taylor Umbridge. Late Night Baking with Mookie Mookie. Allie. Appreciate you, Allie. Tia C. Let's see. Chan My Black. All right, I'm seeing doubles. Indigo Kepera. I see you. Miss D56, I see you. Appreciate you, family. Jazzy T, I appreciate you. And all y'all. So, yeah, like I said, I'll be back most likely tonight to cover the verdict and whatever parts we missed or whatever might be the most important parts. Other than that, you know what I'm saying? Y'all have a good one. Y'all stay fresh. Y'all stay blessed. And peace out, family.
Have a good night. Have a good night. Have a motherfucking good ass night.
Chasing down my goals, I self-law am master, supernatural disaster, metaphysical reaction. I am the flesh, I am the God. No one got the lab on lockdown. Talking hot winters and cold summers. Black Force Ones when we slide.
Shout out to No One. Y'all go sub up to Rock Solid TV. Let me drop the link for Rock Solid real quick.
Come and tap in the most interactive. I am the flesh. I am the God. I am the flesh. I am the God. with the lights up. So you can share, tell them pack in. You're feeling left, right, front to the passenger side. It's right here, the premiere. How you know? Cause them boys broadcast to the live. Wanna talk about it? Hit the link right here. Slide coins up, got 100 bands. Montage, watch how the check. And the band made love to a bobblehead. 2 bands do a dance like check. I'ma keep going till a motherfucking tie. You what? I'm motherfucking tired. Slide real side, could we rain down game? Like, what you mean? Just watch the rise. Watch the rise. Watch the rise. I am the flesh. I am the God. I am the flesh. I am the God. Flesh of the God. I see one. I see one.
Ain't no one, feel free to drop your link anytime. You know, just not the big bulky chats, but you can drop your link, drop a message anytime. Appreciate y'all being here, family. We up out of here. Much love. See y'all either tonight or whenever. Peace out.